everyone. My name is Tom Rudkin and I work in the reputation management practice here at Farrers. Thank you very much for joining us for this third session of day 3 of Entrepreneurs Week. As I'm sure a number of you know, one of our main focuses at the firm is on looking after the interests of entrepreneurs, family businesses, investors and private business as a whole. So this is a really integral week of the year for us, and we're delighted that so many of you can join us for this session, but also all the other sessions across the week. Please do join the conversation on social media. You can see on the slide that the hashtag we are using is EW2020, and feel free to use whichever your preferred platform is. Today, what we're going to do is explore some key aspects of reputation and media management using a fictional scenario. And I'm very keen to ensure that this session is, despite the fact it's being done virtually, as interactive as possible. So please do use the chat function throughout to submit questions and thoughts, or indeed disagree with anything I have to say. My colleague Ed Perkins, who's on the call, will answer some of those as we go through the session, and we'll then return to them in the Q&A at the end. If you do have a burning question or comment, then can I ask you to use the raise hand function, and then between us we'll keep an eye on it and we'll try to come to you as and when. But otherwise I'd be grateful if you could keep your microphones on mute. And we will be recording the session for those who haven't been able to attend, so bear that in mind in anything you say. Before I set out the scenario we're going to work through, I thought it would be helpful to give a short overview of the law relating to reputation management and media and information issues. In the team, we advise clients on a range of issues, from mainstream media coverage to social media posts and search engine results, through to a much wider variety of other matters that impact on clients' reputations, their privacy, or in the case of companies in particular, their confidential information and the data they hold. I think it'd be fair to say, in very general terms, that the UK has strong protections for reputation and privacy, and that's been amplified by the impact of data protection laws, which I'll come on to in a little bit more detail later. Having said that, there is at the heart of the law an underlying tension between the privacy, reputation and information rights of individuals and businesses on the one hand, and on the other hand, the right to freedom of expression that news outlets and other members of the public have. And that permeates through almost every case that we look at as a team. And how that tension is resolved is really dependent upon the facts of the case. So there's no one-size-fits-all approach. It's not as if privacy or freedom of expression take precedence. And in that respect, the UK is different to some other jurisdictions, such as, for instance, the United States, where you have the First Amendment embodied in the Constitution and where freedom of expression often takes priority. So that's kind of an overview to bear in mind. And we'll talk through that in a bit more detail now on a scenario that I've put together. I should say at the outset that this scenario is entirely fictional, so don't read anything into it, beyond the fact that I've taken little bits from a scandal involving a company called Theranos that some of you may be familiar with. So what I'll do is I'll read through the scenario, and then we're going to talk through various developments that happened to this business. So it's on your screen. I'll read through it and then we'll talk through it in a bit more detail. With the demand for health innovation at an unparalleled level as the world struggles to control the coronavirus pandemic, a number of home testing kit providers have sought to gain endorsements from public and private healthcare services. Foremost among these is Peirasmos, creators of a revolutionary new product that enables patients to test themselves at home, generate results, and upload the data to the accompanying app. Peirasmos is led by Dr. Alexis Holmes, a charismatic former GP who has been in the health technology space for several years. After a number of failed enterprises, Dr. Holmes appears to have struck gold with Peirasmos. Private healthcare providers are queuing up to take orders of its products, while they are also in talks with government for the purposes of supplying the products to NHS patients as the winter approaches. While Alexis has kept Peirasmos technology closely guarded, the currency of the product and his frequent posts on social media mean that it is likely to become widely known to the public in the near future. And he's been approached by the Times for a profile piece while he has several crunch meetings with NHS executives and NICE in the coming weeks. However, there are a few skeletons in the closet. 7 years ago, while he was a GP, Alexis was the subject of disciplinary proceedings brought by the General Medical Council following allegations that he had engaged in dishonest conduct when treating a neighbour and was practicing without insurance. While he was given a warning for practicing without insurance, the allegations of dishonesty were dismissed by the Medical Practitioners Tribunal. There have also been some murmurings of discontent from 2 employees in the app development team about Alexis's leadership style. And in particular, his deputy head of creation was previously dismissed for gross misconduct and subsequently challenged the decision unsuccessfully via the Employment Tribunal. But despite some challenges and bumps along the way, Alexis and the company's leadership are excited for the times ahead. So we've got a mid-sized business with a pretty prominent founder. Reputation of the business is likely to be inextricably linked with the founder. And we can think of some other examples that fit that bill. One that really springs to mind for me is WeWork, but there are other examples of that. Theranos is another. There's some level of profile to this business at the moment, but clearly that profile is going to be catapulted by some of the negotiations that they're engaging in with government and other private healthcare providers. But it's a time of heightened risk to reputation because of the potential scrutiny that some of the conversations that they're having and the negotiations they're having may give rise to. One thing I should say is I'm not going to talk in detail about data security today. Clearly, that's something that a business like this would need to be extremely mindful of from both a reputational and regulatory perspective, given the health data involved in the app process of uploading that data to an app. But that's really a talk for another day. So the first development that happens is on your screen. And Alexis has got this interview with the Times, and he's been reminded by the company's marketing and comms director that while the Medical Practitioners Tribunal in the GMC case is no longer available on the GMC's website, several local newspaper reports from the first day of the hearing can still be found online. And there are also some photographs on Alexis's Facebook page of an ill-judged university night out where he dressed up as LeBron James, complete with blackface. So I think this is obviously very common where you have a digital footprint that can cause difficulties from a reputation perspective. And it's something that we find clients are increasingly aware and mindful of. Obvious first step in these circumstances is to try and remove the photos from Facebook. That's a fairly straightforward, practical step that you can do on your own profile. It doesn't require legal advice or indeed any other particular advice. What we don't know in these circumstances is whether the photographs have been shared anywhere else. And clearly it's an understatement to say that they're not going to be helpful if they come into the public domain, particularly in the current climate. Depending on who took the photographs, Alexis might also want to try and take steps to secure the copyright in them. He might own them already because he took the photos, but if he didn't and it was a friend, that's something he might be able to try and add to his rights over. And once you own the copyright in a photograph, you've got an even stronger argument to prevent their publication, because in this case, it's difficult to see why else it would be unlawful to publish those photos if they've been shared on a public Facebook page. Clearly, therefore, the preference is that these don't see the light of day, but I think we'd be naive to think that a journalist hadn't already got their hands on these photographs. So he's also going to need to think about what his and the company's response would be if they're more widely published. And so that's going to need some separate communications input, not just legal advice. So they'll need to think about their internal communications operation, or possibly going to an external firm, which is something we often do. We'll often work hand in glove with either the internal comms team or indeed an external PR firm. And they'll need to think about how they're going to explain these photos and what the response would be if they see light of day. Turning to the previous stories about the disciplinary case, it's very common, you see this, where the first day of a trial or a disciplinary case has been reported in the press, and then the outcome hasn't. And you'll only then see one side of the story, which is generally the prosecution or the claimant's case in the litigation. There are two aspects to consider in this case. Firstly, the allegations, apart from practicing without insurance, were found to be untrue. And secondly, this all took place 7 years ago. Now, I suspect quite a number of you will be familiar in general terms with data protection and GDPR, particularly when it comes to things like privacy policies and whether you have consent to communicate with people and keeping data secure. But what we found in the last 10 years is it's also been a very useful tool in protecting the reputation of individuals, because it creates obligations for all organizations to keep the data that they hold secure and up to date. And that includes media organizations as well. They have some protections because they're operating in a journalistic space, but those protections are not absolute. And so we will often use data protection law to remove Google search results, media content that's inaccurate or indeed significantly outdated. And so in this case, given the time that's elapsed, the fact that the majority of the allegations were disproved, and that the GMC is no longer holding the result on its own website, i.e. the prosecuting authority doesn't hold the decision, I think there's a good case for, at the very least, having the stories updated to reflect the outcome and quite possibly also removed entirely. And this is really reflective of the fact that the law recognises that electronic data, unlike print media, is permanent, and after a while it can start to have a disproportionate impact on the rights of an individual, particularly where they've not entirely but almost entirely been exonerated of the more serious charge, like in this case. Taking a step back, what this scenario shows is that there's a lot to be said for identifying reputation risks at an early stage. As I said, in reality, some of this information may well and indeed is likely to have got into the hands of journalists in the present day. But there are certainly steps you can take at an earlier point to identify what information is out there, particularly online, which you might be able to take steps to either remove or have updated to stop it from having a negative impact further down the line. And that's particularly the case in a situation like this, where you have a business and a founder who are going to come into the public conscience in a much greater degree. And we frequently advise clients to conduct their own self-due diligence at as early a stage as possible. And that doesn't necessarily require detailed legal or indeed other advice. There are practical steps that can be taken without having to spend huge amounts of money. Equally, at some points there is good cause to take legal action to have information removed, and technology can also be of assistance here. There are a number of platforms that will help you to identify where information is being published, and again, that's something we are advising clients increasingly on. Unfortunately, that's not the end of Alexis's difficulties. The Times profile piece was a great success, but there have been a number of posts on Glassdoor and Twitter from an anonymous account labelling Alexis as a fraud and a bully. We see there, this is going. The facts, including the post, point towards the former deputy head of creation, who's the individual who was dismissed for gross misconduct. Now, as I'm sure we're all aware, negative commentary by unhappy customers and ex-employees is something that a lot of businesses have to deal with. And the first question from a lawyer's point of view is always, do you engage at all with this content? Sometimes the best approach, particularly where the profile has very few followers or it's seemingly unlikely to cause any reputational harm, is to do nothing, because engaging can be disproportionate from a time and cost perspective, and it can sometimes help to give oxygen to the allegations that you're trying to keep under wraps. The other factor to mention is that content platforms like Facebook, Twitter, and Glassdoor will often try to assert that they don't take sides in disputes between parties, and they do have some protections as a matter of law on the basis that they're hosting rather than creating content. They tend to overstate those protections, unsurprisingly, but they do have some degree of protection. Historically, they've been very obstructive in trying to deal with complaints about content, but we're seeing a definite shift in that. And even in the last week, I've seen social media platforms who were previously always resist taking down content be quite willing to do so. So we're certainly seeing a move. And I think that's probably a product of some of the political pressure going around at the moment, particularly in relation to very harmful online content. We've seen a lot of misinformation and disinformation about the coronavirus. And we've also seen Donald Trump have various tweets sanctioned. So that's the direction of travel when it comes to social media, and I think that's only going to go one way. In this particular example, you can see why the company and Alexis might want to take steps to remove the content. They're very serious allegations, certainly defamatory, and Glassdoor is a pretty widely used platform by prospective employees, and comments from an ex-employee might therefore be seen to carry some weight. And there's obviously the wider context here, which is the increasing profile of both the founder and the company, and that looking like it's going to increase with some, hopefully from their point of view, big government and other contracts. So in this case, I think we might want to take some steps to try and have the content removed. It's clearly defamatory, as I say, and it also constitutes Alexis's personal data. So it engages the data protection issues that I touched on earlier around accuracy and keeping matters up to date. And actually, data protection can be a very useful tool against some of the social media platforms, because they will tend to have some kind of establishment or office in the UK, or at least in the EU, and that puts them within the remit of EU data protection laws. And so, whilst they might try and resist claims in defamation and other causes of action, it's more difficult for them when it comes to data protection. So, assuming in this case Alexis and the company are able to provide some persuasive evidence that it was the former employee who was behind it, whether because there's some identifying information that points the direction very firmly towards him, or there's some information in the post that only he would know, I think we'd be suggesting that you'd write to the two platforms explaining that Alexis and the company know who's behind the posts, and that they've previously made the allegations in an employment tribunal case, which was dismissed. And that kind of independent adjudication from a tribunal or a court can be very helpful, particularly dealing with social media platforms, who, as I mentioned earlier, tend not to like censoring their users for content that someone simply disagrees with. The other question that springs to mind is whether you should be taking action against the ex-employee in a case like this, and that has to be carefully considered, because it could in its own right give rise to publicity if you take formal action against them. But if you were to do so, there might be enough evidence to write directly, but there's also a process whereby you can apply to the court for an order that requires the likes of social media platforms to disclose account information where they're mixed up in the wrongdoing of someone else, i.e. They're not directly responsible for it, but they're hosting content that is unlawful in some way. And that's an option to consider when you have anonymous accounts posting unlawful content. And I've had cases before where you really do strike gold with those types of applications, and they point directly to the person who you think is behind them. We talked about communications earlier. I'd certainly be wanting the company's internal and external comms advisors to prepare for any questions that might come in about these allegations, whether from clients or indeed the media or indeed prospective employees. Again, preparation is absolutely key when it comes to reputation management. And it's certainly key in this case. So our final development is the sort of the standard work of the media lawyer, which is questions on a Friday afternoon from a journalist, requiring a response within a very short deadline, and potentially requiring the client to take very quick steps to find out information and produce a response. So Alexis receives an email from a journalist at the Daily Mail explaining they intend to publish a story on the Saturday before a make or break meeting with various NHS trusts. The story will allege that Peirasmos has been exaggerating the speed of its test capability, and will also contain claims about Alexis himself, including that he was previously accused of dishonest conduct whilst operating as a GP, and that he exhibits bullying behaviour. And Alexis intends simply to ignore this and refuse to comment. I think first thing to say here is that no comment in a response to a story like this is absolutely not the way to go. And I tend to think that no comment is very rarely the right response to an inquiry from a journalist. There There are some rare occasions where that might be the case, but it never looks particularly good when a newspaper is able to say that the subject of a story simply declined to comment. And in this case, I think there are going to be some considerations both from a legal perspective in terms of trying to prevent part or all of this story, and then in terms of what the company might say publicly to mitigate any damage that a subsequent story might give rise to. One of the reasons that you will get this email before a story comes to light is that the newspapers and broadcasters will put questions to the subject of a story, and are generally required to do so as a matter of law. That's not an absolute requirement, but it's generally more difficult to justify a story if you get it wrong and you haven't put it to whoever the story features. And it also helps the media to understand whether what they're being told by their sources is actually accurate. So this email actually presents an opportunity for Alexis and Peirasmos to highlight any ways in which the newspaper, the Daily Mail's publishing allegations that would be unlawful, or to think about how they're going to respond publicly. And one of the problems with the no comment response, as well as potentially implying either an admission of guilt or at least a failure to engage properly, is that it will be something that a newspaper or a broadcaster is able to rely upon if you then want to complain after the story is published. So whilst they're always going to be responsible for what they publish, and will have to find some basis for doing so as a matter of law, there's a public interest defence, for instance, to defamation cases where what the publisher does before publication can be helpful to them, even if they can't show conclusively that the story was true. If they can show that they took reasonable steps to verify its accuracy, then they're potentially going to have a defence if it's on a matter of public interest, which this undoubtedly is. So that's really where the pre-publication engagement becomes very relevant. Some key initial principles, and these are really just practical issues. Try to find out the deadline and potentially extend that deadline if need be. You don't necessarily want to be providing any on-the-record comment until everything has been looked into. And this is something that communications advisors and PR teams will be all over. And then start work quickly to get to the bottom of the truth of the allegations, because you need to have the facts in front of you to then decide how to respond. So turning to the case in point, I think I would be looking at a legal letter before publication on a not for publication basis. So this would be set out as something that isn't to be published in the newspaper, and generally the press will respect that. And they should be explaining that to the journalists that the allegations of dishonesty were looked at by the medical practitioners tribunal and were dismissed. And if they were to be published, if it was to be said that he had acted dishonestly, that would clearly be false and also defamatory and likely to cause serious harm to his reputation. So you're putting the newspaper on notice that what they're proposing to publish is wrong and could give rise to legal liability. It might also be that the allegations of bullying originate from the ex-employee we've talked about already, who was dismissed, in which case it's probably going to be possible to discredit those to some extent as well, because the employment tribunal case was unsuccessful. But when we looked at the scenario earlier, it was suggested that there was a bit of a wider sense of discontent. So if the journalist is working from multiple sources, then Alexis and the company will need to try and ascertain who those sources are. Clearly, they're not going to get that information direct from the journalist if those sources are not on the record, and get to the bottom of the facts and try to create a response. And it might be that those allegations can be discredited as well, and we could think about how that would be set out in any legal letter. We'd also want to consider what the basis was for the suggestion that the test times have been exaggerated. There's very little information in the slide, and you might also even think about going back to the journalist and asking them to provide further information if the basis for that allegation isn't clear. You need to be, it's only fair that the media give you a proper opportunity to respond. So I think where we would get to in a situation like this is a not for publication letter from lawyers which seeks to shut down as much of the story as possible, focusing on the elements of it that are false and defamatory, and putting the newspaper on notice of these risks. But to take as an example, if the testing capability had been exaggerated at any point, or if there was some grey area there, then again, I think there's going to need to be some consideration to the possibility that this story might well end up being published, albeit hopefully in a watered down form. And again, going back to a theme that I've mentioned throughout, think about what the company and Alexis would say publicly about that to try and reduce the damage. And that's not a legal question. That's a question for the comms team, who, as I say, we would work very closely with. And that combination of public relations and communications and reputation management and legal advice is absolutely key in a situation like this. That's really what I wanted to say, just to give you a flavour of how we would approach a case like this. These developments are very symptomatic of the kind of work that Ed and I do on a daily basis. So it is based on reality, and I think some of the key points to take away are really early preparation, particularly if as a business you're likely to become particularly develop a particular public profile, but also really taking steps to identify any reputation risks that might exist, and that includes both the obvious kind of crisis management planning that all businesses should be looking at, but also potentially looking back to the past to identify any risks that might lie there, and that could be something as simple as a Facebook photograph, as we mentioned, or it could be something that happened in a previous career. But all these things, because they're around so permanently now, unless steps are taken to remove them, can cause difficulties further down the line. Ed, I thought I'd hand over to you now, see if there are any questions that have come in from everyone listening in, or indeed if you've got any thoughts of your own.
There's one question at the moment, Tom, from Jack West Shering, who says that Tim Berners-Lee said in 2015, during the 800th anniversary of the Magna Carta, that we need a new constitution for the digital age. And do you have any thoughts on this? And would it be helpful for reputation management? And the one thing that sort of struck me there, Tom, and Belmin's step in as well, is I was referring to a client just the other day about the government's attempts to, as best it can, regulate online harms in the digital environment in the United Kingdom. And the British government has certainly, when the white paper was published, which was over a year ago now, but has indicated that it's going to attempt to mitigate some of the most egregious effects of anything from the very big stuff. So hostile actors, we're talking about nation state to nation state, or terrorist groups, or criminal gangs. But also the UK government is definitely recognizing that there are other behaviors and content online which isn't in itself potentially illegal, but it can cause serious harm. So it's talking about everything from harassment to bullying to intimidation, and that's to individuals who are vulnerable or people who are otherwise public figures, young adults and others. So I think there's a recognition, certainly at governmental level, that the unregulated space that is not quite the Wild West of the internet as was 20 years ago, but still exists in some quarters. It's making efforts to try to mitigate the very worst elements of that.
Yeah, I think.
Go on, sorry.
Yeah, no, I was going to say I think that's right. And the online harms white paper that you mentioned is quite interesting, because this is a new proposed set of legislation in the UK, which is going to try to regulate the processes that the likes of the social media platforms and search engines have in place to protect users from harmful content. What they're not suggesting at the moment is more direct regulation of individual cases. And I think there's a feeling and there was a House of Lords committee report on this, that doesn't quite go far enough, because it's still going to involve self-regulation by the platform. So they'll be at the moment, the way they regulate complaints that are made into them, unless you sue them, is through their own internal processes, and those processes are not particularly developed, to be honest. And I think the online harms paper goes so far, but I mean, it's a fascinating question as to whether you need a kind of wider constitution. I think you probably do. I think there needs to be more recognition of the fact that serious damage can be caused by individuals posting inaccurate, harmful, private, defamatory content online, and that goes right from very low-level individuals who have small followings but engage in quite serious harassment or post very, as you were saying, sort of hostile content, through to people at the top of politics. And that's what's been quite interesting about this year, is seeing the likes of Twitter take a more proactive approach in relation to some of the posts from the likes of Donald Trump. I think that the platforms are coming round to the idea that they can't sort of subsume all this data and reap the benefits of it without taking a more proactive role. But I suspect they probably didn't anticipate this, and so I do think there's a lot to be done to try and regulate how that works. And at the moment, that online harms paper, I mean, the other thing about that is we don't even know when it's going to come into force. So it suggests government are serious about it, but who knows when it's going to happen? And clearly, it's not top of the priority list at the moment.
And just one other thing to add as well is that, of course, it's all very well having a constitution for this jurisdiction, for the UK, but that completely fails to recognise that most of the issues we have with clients are not necessarily those who simply have an issue with perhaps the Daily Mail or google.co.uk, or even with the European Google search result. It is more likely than not will involve an individual or a company or an organisation who have issues with jurisdictions outside of the EU. It could have nothing to do with the UK. Maybe a Saudi individual working on a South African company, and a British or a UK rather constitution only goes so far then, because we're already operating in an environment in which if you're going to have a constitution at all, it needs to be global, which is hopeless, obviously.
Yeah, I've had something this week actually where I've been dealing with two separate Russian social media platforms, and one of them is very easy to get hold of and seems to be pretty cooperative. The other, it's almost impossible to work out where it's even located. It doesn't seem to be located in Russia, and it seems to have moved from jurisdiction to jurisdiction, or probably to try and avoid the likes of me writing to them, I suspect. Any other questions, Ed?
No, but I wondered, another point I was going to make, Tom, was that we've had a couple of clients where the issue has been, in the first instance, with perhaps something like the Daily Mail, as described here. It's always the Daily Mail, or as was News of the World or Mail on Sunday. But so the issue in the UK is with the UK newspaper. But the greater issue is probably then that article will then appear within a Google search result. And you've obviously touched on the idea that within the EU you've got the GDPR to be able to fall back on and at least attempt a right to be forgotten request with Google. And you also mentioned the idea then that you could also, for example, if you've got photographs that exist that are incriminating or at best judiciously described as awkward, or such as the ones in this instance, that you could assign the copyright to yourself. I think it's quite important, and then have them taken down on that basis. I think it's quite important to understand that while that may actually work bizarrely, it might work for the Daily Mail, because they'll find themselves having to answer to UK copyright law. I've had clients recently where we're trying to get photographs taken down from a Google search effectively. So they don't really care that it's on the Daily Mail website because that's one article. People aren't actually looking for that. What they're looking at is if when you type in the client's name, one of the first thing that comes up are images that are on other websites, and they're probably based in websites in the US, or there's a network of conspiracy theorists who are producing material left, right, and center. And it's very difficult to persuade Google in that instance to take material down on the basis that it's an infringement of copyright, because they simply don't recognize or can't be bothered to recognize, or unless you present them with a letter before action, and even take it further than that to litigation, UK copyright law. So they will fall back on, I've got a client at the moment who's battling against the US DMCA, which is the Digital Millennium Copyright Act in the US, and that recognizes the right of virtually anyone, conspiracy theorists included, to publish your information or publish your copyright material. Take photographs. Take, for example, the photographs in this example here. And whereas we might have relatively easy success taking them down from the Daily Mail, because we'll say there are photographs, we own the copyright, and there's no fair dealing in this sort of material. Elsewhere, and the US included, and mainly, there is a protection for websites, whomever they are. It comes with caveats and it has provisions, but generally, if they wanted to use that material, it's very much easier for them to use it in the US, and so you'll find that you have success with the Daily Mail and not perhaps with Google. I'm not sure what point I'm trying to make, other than you throw as much of this at as many actors as you can, and including Google, and we'll send the same letters to Yahoo and Bing and others, and indeed the originator of the material. But you can have a very patchwork response and result depending on what the material is, on what grounds you're asking it to be removed, and where you're asking it to be removed from. So something can go from the Daily Mail but stay up on the New York Times, for example.
Yeah, I think that global element is ever increasing. I mean, the number of cases we do now, which particularly if you've got an individual or a business with international interests, you're no longer just dealing with the front page of the Sunday Times or even the back pages of a national newspaper. The content can pop up in all sorts of different places, and UK law can help with some of that. And data protection law, as I say, has really been a game changer because it has quite a far reach, and that was something that the EU were quite deliberate about when they brought in GDPR, so that it means that companies outside the EU can still be caught by it and have to respect the privacy rights of individuals in the EU and in the UK now. But it's definitely a challenge because you have you have this information that will appear in one place and it will just propagate very, very quickly. And so that it becomes very important to identify where it is early and try and have a strategy in place to sort of pick it off. And I mean, Ed, you and I, we've both been doing cases recently where we're dealing with orchestrated disinformation campaigns that are almost, I mean, they're not state-run, but they could be in their sophistication. And that presents very interesting challenges. But I think, I mean, I'd like to think that the law is moving forward fairly quickly to try and protect clients who have to deal with that. I think certainly there's been a shift in the case law here towards greater protection, particularly for individuals, but I think also for organisations as a whole. And we're certainly finding that with online content, we're seeing greater success and greater cooperation from some of the platforms and search engines like Google, etc., that perhaps we've been very resistant 10 years ago to taking anything down, but they're just having to change the way they approach. And ironically, that's actually being assisted by some of the media organisations that we take action against, because they're drawing it to the attention of public conscience and to government who are trying to find ways to regulate it. But we've got a way to go, definitely. Okay. Well, I'll open it to the floor in case anyone wants to jump in with any thoughts or questions before we sign off. feel free to turn your mics off if you have got a thought. Otherwise, I will say thank you very much to everyone for joining. I hope it's been interesting. I'll show you our contact details, which we will circulate. If you've got any questions about the session or want to know anything more, please don't hesitate to get in touch. Enjoy the rest of Entrepreneurs Week.
Tom, just one little question down there. I don't know if you're perhaps monitoring the screen, but it's this is from Beth, who asks, what kind of timeframes are you looking at if a journalist comes to say they're intending on publishing something and the business needs to go away and review the claims? Is it for the business to set a deadline, and are the media outlets normally cooperative?
The answer to that is no. It's generally quite a short time frame. I mean, if you were to receive a communication on a Friday or a Thursday evening, you might be given the whole of Friday to come back. Sometimes it will be shorter than that. It slightly depends on the number of allegations that are contained in the story. If it's a particularly detailed story, then they will give you more time. You can sometimes negotiate an extension, particularly if the story isn't of any given urgency and they need to give you a proper time frame to respond. But ultimately, they will make a decision on when that deadline is. You can press them and push them back and explain to them why they need to give you more time. But it's not laid out by the subject of the story. You don't have complete control over that. So there's a game of cat and mouse when it comes to when you respond as well. I mean, often you'll try to leave it quite late up to their deadline, but there are risks of doing that in the sense that they may not have that much time to change what they're going to publish. So you need to give them enough time to go off to their own internal legal team and get advice, which hopefully might be, well, we don't think you can run this story, or you need to tone it down significantly. So it's a moving picture, but in general terms, you have to play with them a bit to get that deadline resolved. Okay. All right. Well, thanks very much, everyone. Contact details are on the slide that you can see, and hope to see you again soon. And please do get in touch if you have any questions from the session. Many thanks.